Hello and welcome to today's session on exclusions and debarment. I'm Patrick Saunders, I'm an associate here in the public sector team.
And I'm Tim Kerr, and I'm a partner in our public sector team.
So as I say, today's subject is about exclusions and debarment. Can you describe why this is important, Tim?
Yeah, I certainly can. So as a matter of government policy, there's an exclusion regime which allows contracting authorities to exclude certain suppliers from taking part in procurements or from being awarded public contracts if they pose particular risks. I know that sounds a bit odd, but we'll explain later what that means. So the regime allows contracting authorities to consider a supplier's past behaviour or maybe performance and various other circumstances to determine whether or not they should be allowed to compete for public contracts. Just to be clear, the government insists that this is not by way of punishment on suppliers who've done something wrong in the past, and it's also not designed to be a deterrent, but their mantra is this is a risk-based approach, and it just ensures that the wrong suppliers don't find themselves awarded public contracts.
Right, okay. And how does this fit in with the procurement regime?
Well, first of all, this regime has existed for a long time under our public procurement rules, which obviously were governed by EU rules pre-Brexit, and the regime continues under our new legislation, the Procurement Act 2023. Broadly speaking, a contracting authority, when they're carrying out procurement, we are required to check whether a supplier is caught by these exclusion grounds, and that usually happens right near the start of the process. It doesn't necessarily have to, but commonly it happens at the very start of the process so that you can basically weed people out early on and they don't proceed through the procurement process.
Mm-hmm. Okay, and you talk about exclusion grounds or grounds for exclusion. What does that mean? So there are two types of exclusion ground, mandatory and discretionary, and they mean just that. Mm-hmm. So fairly self-explanatory. So if there's a mandatory ground for exclusion, the contracting authority has to exclude that supplier. If there's a discretionary ground, clearly it's got a discretion as to whether or not to exclude that supplier. And just in terms of getting the jargon right, the Procurement Act 2023 has introduced some new jargon and two terms, one the excluded supplier and one the excludable supplier, and you can probably work out that the excluded supplier is someone who's triggered a mandatory ground and the excludable supplier is someone who's triggered a discretionary ground. Okay. Can you give us any examples of exclusion grounds?
I can. So first of all, if you're really interested in this, you'll find them in Schedules 6 and 7 of the Procurement Act, which I always keep by me at all times because you never know when you need it. So they're quite easy to find. Schedule 6 sets out the mandatory grounds for exclusion. So these are the most serious sort of high-risk grounds, as you'd expect, really. And Schedule 6 itself is divided into two parts, but the first part requires a conviction for a fairly serious offence in the UK, or even a conviction for an offence overseas, which would also be an offence in this country if it had happened in this country. And the sorts of things that are covered in the first part of Schedule 6 are things like corporate manslaughter, terrorism, fraud, bribery, modern slavery. So you get the feel, you get the flavour of that, don't you? Yeah, this is pretty serious. So you can see that as a matter of public policy, you don't want people like that being awarded public contracts. The grounds that are in Part 2 of Schedule 6, so they're still mandatory, are different because they don't require an actual conviction of a criminal offence, but they're perhaps more regulatory, so things like tax misconduct or some sort of competition law infringement, things like that would be caught in the second part. Now, so those are mandatory grounds.
Yeah.
Discretionary grounds are set out in Schedule 7. These include things like the beautifully named labour market misconduct, environmental misconduct, insolvency, competition infringements, professional misconduct, acting improperly in a procurement, which is a nice one, and also breaches of contract and poor performance of contracts.
Okay, have you got any examples of what labour market misconduct might include?
Well, yeah, I had a feeling you're going to ask me that, so I came prepared. So it might be, for instance, where some sort of notice has been issued against a business because of infringement of the modern slavery rules.
Okay.
So not necessarily a conviction of an offence, but some sort of infringement. And also, similarly with immigration rules, sometimes a business won't be convicted of an offence, but there'll be some sort of regulatory order imposed on them for breach of immigration rules. So those sorts of things will fall within the labour sort of market misconduct.
Okay, and how about acting improperly in relation to a procurement? I mean, I can think of some examples, but I'm sure it's a little bit more formal than that. So what does that mean?
Yeah, that's an interesting one. I mean, this has been around for a while. It's basically where the supplier's guilty of some sort of improper conduct, which has put it at an unfair advantage in a procurement, in a public procurement. So the sort of thing would be if they fail to provide information that's been properly requested by the contracting authority in a procurement, or they provided information but it was misleading information, or they've attempted to influence a procurement process, sometimes by improperly communicating with procurement officers or something like that, not following the rules of the procurement. So it can actually be quite broad.
Yeah, I was going to say that sounds like quite a broad thing, and people are going to have to be very careful about who they talk to and what they say, aren't they?
Yes.
Yeah.
Yeah. No, absolutely.
You also mentioned breach of contract and poor performance. What's that going to entail?
Well, this is an interesting one because some of this is new under the Procurement Act 2023. So we're going to have to get used to this and see how it operates. So broadly speaking, a discretionary ground for exclusion can be triggered if, and there's two limbs to this. First of all, if a supplier has breached a public contract, with the result that either that contract has been terminated, or there's been some sort of settlement agreement, or there's been an award of damages against that supplier.
Right.
So that's the first limb. The second limb is there can be a discretionary ground for exclusion if the supplier has not performed a public contract to an authority's satisfaction, has been given an opportunity to improve its performance, and has failed to do so. Now that second limb might not necessarily be a breach of contract. So you can see here where that's why we call it poor performance. It's not necessarily a breach, it's poor performance. This all ties in with the new sort of transparency rules that have come out of the Procurement Act 2023. We're probably going to speak about those in a separate session, but just to touch on them for now, if a supplier has breached a contract, which has resulted in, as I said, termination, settlement agreement or damages, or if it's been guilty of poor performance, as I described it earlier, then actually the contracting authority has an obligation, and it is an obligation on that authority, to publish a notice on the new central digital platform to that effect. So you are telling the world, or whoever decides to log on to the central digital platform, you're telling them that that particular named supplier has been guilty of a breach of contract or has been guilty of poor performance under that contract. Because that information is public, it's searchable, so future contracting authorities who are going through new procurements can validate that information by just looking on the platform, checking against that supplier, and checking that information is true, and therefore that there's a ground for exclusion. So this is potentially quite a controversial area, and clearly one that's going to worry, I think, private sector suppliers, because if they slip up in any way, even if it's accidental, they could find themselves named on the central platform as a supplier who's breached a contract or is guilty of poor performance.
It will be interesting to see how that plays out, because presumably there won't be any context to give reasons behind that breach either.
There will be a certain amount of information you're required to give in the notice as the contracting authority, but you're not going to tell a big story.
No.
Chances are you're going to give as little information as possible. So yes, there is a danger that information is actually taken totally out of context. So we'll have to see how that one develops over time.
Okay, it's all very interesting. But how would a contracting authority find out if a ground for exclusion applies? Save for...
Yes, well, the starting point is, and I think we've talked about this before, that usually at the beginning of a public procurement, the contracting authority asks for a certain amount of information from the bidders, and under the new regime, there's a certain amount of core information about each bidder, which should be registered on the central digital platform. Registered against that supplier's name and identifier. And that information should then be made available to the contracting authority, and that will include a statement as to whether or not any of those grounds for exclusion apply. So at the very start of a process, the contracting authority will have that information, which will tell it whether or not the ground applies. You're probably going to say to me, well, how do you know it's true? Obviously, there is an ability to verify that information. So what we've just talked about in terms of performance, if it's happened in the past, there'll be a notice published against that supplier, which will be publicly available. Also, bear in mind that if a supplier gives false information, then they could be liable to be sued for sort of a fraudulent misrepresentation, or potentially even for fraud. So the incentive is on suppliers to give accurate information.
Okay, and does a ground for exclusion last forever, or are they time limited?
Yeah, there is a time limit, because it would be a bit unfair. Yes, a bit harsh if once it's out there, you can never bid for a public contract ever again. Now, it is currently the case with the rules pre-Procurement Act that there's a time limit on this information and on the exclusion ground, and that's going to continue. Broadly speaking, and I won't go into too much detail, there's a sort of a 5-year limit from when the event happened or when the conviction was made for that event. So yes, in a sense, these exclusion grounds can be spent, to use that language.
Okay.
Yeah.
Okay. What if it isn't the bidder who has the problem with these exclusion grounds, but maybe another group company, one of its subcontractors? Is that also going to cause a problem?
Yeah, now this is an interesting point, and this is an area where the Procurement Act 23 has kind of, I think, tidied up and clarified the situation, because I've come across situations, and I'm sure you have in the past, where a contracting authority has been worried because it's looking to award a contract to Company X, but its sister company in the same group, Company Y, has been all over the press because they've been guilty of some health and safety failure or something like that. There was a famous instance after the Grenfell tragedy where a company had been awarded a contract, and within the same group was the company that had been fitting the cladding to Grenfell Tower, and they didn't want to award the contract because they thought it was just too difficult and too embarrassing to do so. Now the rules now are that when a contracting authority is running a procurement, it's required to consider whether the exclusion grounds apply not just to the actual bidders, but to anyone who has a significant influence or control over that bidder, such as a parent company or the owner, or anyone that the supplier itself has got a significant influence over. So it could be a subsidiary, for instance. And also, the contracting authority should look at what are called associated persons. So that, for instance, could be anyone that the supplier is relying on in order to satisfy the conditions that have to be met to win this contract. So, for example, that could be a first-tier subcontractor. So the bidder's bidding for the contract, but it's going to subcontract quite a chunk of that to a main subcontractor. That subcontractor will be an associated person. Yeah. And the guidance gives, if you're interested in looking up the guidance on this, it gives some very good examples of the types of instances where you might have that associated person relationship. So in a way, no matter how the supplier structures the bid, if there's another party involved who's going to be delivering a fair chunk of the services, then they're going to be an associated person. And in that case, the contracting authority must ask for the same information in relation to that associated person or that person with the significant influence as it does the supplier themselves. And if it finds that there are grounds for exclusion there, then it may be that it can exclude the supplier because of the problems with its subcontractor or its parent company or whatever.
Okay. I've come across the term self-cleaning. Is that relevant to exclusion grounds?
Yes, it is. Now, again, self-cleaning is something that applies pre the Procurement Act 23. Okay. So it's not new. But actually, some of the specific language around exclusion grounds has changed. And I think this is quite an important point, because the way I've described it so far, you would think that once the ground for exclusion is met, that's it. Mm-hmm. You're either excluded because it's a mandatory ground, or there's considerations to whether you should be excluded because it's discretionary. Yeah. But actually, there is another test that runs alongside that. So if that ground exists, then the authority must also ask itself, is that ground likely to continue, or words to that effect? Now, it might be that the authority can satisfy itself that it's not likely to continue because of information that the supplier gives it, to say, well, no, actually, we've dealt with the problem. Yes, we were convicted of an offence, or yes, we had this regulatory notice served on us, but we've dealt with it. And again, the guidance on this is quite good and gives examples of the sorts of things that a supplier might say in order to self-clean in this case. And it might be, for instance, that there was a fine and it's paid the fine, or it might be that it put a sort of action plan together to deal with the problem, and it has enacted that action plan. It could be all sorts of things, but if it gives appropriate evidence to the contracting authority that it has dealt with the problem, mm-hmm. and it convinces the contracting authority that it has done so, therefore it could be that exclusion ground is not going to continue, is not likely to occur again, and the contracting authority might therefore decide not to exclude on that basis. So that is how self-cleaning works in this context.
Right, and you've referred to the guidance a couple of times. Where can we find that guidance?
So the Cabinet Office, in the run-up to the Procurement Act coming into effect, has published a lot of guidance. I think, I've lost count, but there's something like 40-odd separate bits of guidance. If you go onto the Transforming Public Procurement website, you will find the guidance subsection and click into that, and you'll see a list of all the guidance. And I would just recommend that to everybody. Mm-hmm. I wouldn't recommend you read every single guidance, because I think you'd be very sad to sit and do that. But if you're particularly interested in a particular area, look it up, because the guidances have been well written. They're very readable. They give examples of how things apply, which is why I've been referring to it so much in this, because this, let's face it, exclusion grounds is quite a dry subject. So you need to kind of think of the examples. The guidance is very helpful.
Brilliant. And does any of all of this that we've been speaking about apply for the award of contracts under dynamic markets or frameworks?
Well, yes. No, it does apply. So in the case of a call-off under a contract, everything that we've discussed regarding kind of disregarding tenders and excluding suppliers will apply. And that's why when a contracting authority sets up a framework, it has to continually assess whether or not a supplier has triggered one of these grounds for exclusion. And in fact, the Act says you cannot award a contract to a supplier who has become an excluded supplier.
Yeah.
So within frameworks going forward, I think you're going to see this mechanism for ensuring that information is updated and refreshed, or maybe that the suppliers have to reaffirm on a regular basis that the grounds don't apply to them. So under frameworks, absolutely. And then dynamic markets, the way they're going to work in the future is that once you've set your dynamic market up, when you want to award a contract, you actually have to advertise and use the competitive flexible procedure, and therefore effectively you're using the Procurement Act procurement procedures, and that includes the obligation to check whether there are any exclusion grounds that apply.
Right, okay. So I've noticed that so far you haven't mentioned debarment. How does this fit in?
Right, well, debarment is new.
Okay.
Some might say it's the icing on the cake. Others might say this could be the depths of despair for some suppliers. So everything we've discussed so far is relevant for the contracting authorities. They have to assess whether or not a supplier has triggered a ground for exclusion, and then what to do if that's the case. Debarment comes in at a slightly different level, because debarment is something that's decided on by a minister, by government. Now, the way this will happen is that if a contracting authority excludes a supplier on the grounds of either a mandatory or discretionary ground for exclusion, then that information will be passed up to government, and the relevant minister, it sounds like a very exciting job for a Minister of State, I have to say, the relevant minister can decide whether or not to investigate, and I assume that an investigation will only take place if there's something quite serious brought to the attention of government. But they can investigate, and if they consider that those grounds are serious enough, they could place that supplier on this new debarment list. And the point is that once you're on the debarment list, that in itself is a ground for exclusion.
Okay.
So you don't have to worry about any of the other grounds. If you're on the debarment list, then if you're on the debarment list because of a mandatory ground, then you must not be considered as a participant in a procurement.
Okay.
If you're on the debarment list as a result of a discretionary ground, obviously the contracting authority has a discretion as to whether or not to exclude you.
Okay. This is getting quite complicated. So how does the supplier get onto the debarment list in the first place?
Yeah, well, as I say, there's this process, which at the moment, because the Act hasn't started, is somewhat theoretical. But it starts off with the contracting authority notifying the government and publishing the information you've excluded someone. Minister of State takes that, decides whether or not to investigate. The investigation process obviously should be transparent and fair, so the supplier will know that that's happening. They will be required to supply certain information and required to cooperate with that. They will also have the chance to make representations.
Okay.
But ultimately, it's a decision of the Minister of State, and once the Minister of State has made that decision, and have decided that it's a serious matter, and that the reason for them being excluded is likely to continue or likely to reoccur, which will be a factor they'll take into account, then they will decide to put that supplier on the debarment list. Okay.
And how long does a debarment last?
Well, a bit like we were talking about earlier in terms of kind of spent convictions and exclusion grounds, there is a time limit, and it's roughly 5 years from a particular starting point. There is a right to appeal, actually, right at the start, but the supplier's only got 8 working days from when it's notified of the decision to make an appeal. If it does apply for an appeal, there's like a temporary suspension whilst that's played out in the courts. But if it loses the appeal, then they go on the list, and they should come off after 5 years, which obviously is quite a long time.
Yeah, no, it is.
Yeah.
And generous 8 working days to launch an appeal. Yeah. So taking all that in, What would you say are the main points to take away from the new Procurement Act?
Right. Well, in relation to exclusion grounds and debarment, I think the two things that stand out for me, and I think that's come out of our conversation, isn't it, is the expansion of the consideration of breach and poor performance by a contractor. Mm-hmm. And I think it is interesting to see how that's going to play out. But I think that's quite controversial, and we'll have to see how both contracting authorities and suppliers manage that, particularly the piece about poor performance. And the other key takeaway is the debarment list. Mm-hmm. And I think people are, particularly on the supplier side, are quite concerned about that.
Yeah.
Again, we're going to have to see how that plays out. I imagine that it's only going to be applied in serious cases. But apart from anything else, government doesn't have the capacity to investigate lots and lots of instances. Although, having said that, in my career, I've rarely come across an exclusion ground actually applying. It does happen from time to time, but they're not that common. But I imagine a minister would take it seriously if there's been a really serious breach or a series of breaches that make it think, from a public policy point of view, we've got to stop this person getting public contracts.
Yeah. Well, thank you for that, Tim. That's been really helpful.
Thank you.